All right, so back to case study number 2 and question number 6. So when an offer is made, can the civils sell their house as is and avoid liability? What happens when a seller puts a property up and says as is? What does that mean exactly?
Not gonna fix it up, we're not gonna do anything with it, here it is.
Right, you're going to buy it the way that it is. So the question asks, if you do that, can you avoid liability?
No.
All right, so you say no. So what does that mean you can't do? I mean, just because you say as is, what does that mean that you can't do?
We can still lead right after we talk about.
Yeah, you still have all the same disclosure obligations, whatever those might be. So if it's an exempt entity, like a bank that took it back in foreclosure, or an estate trustee, or something, somebody like that, that's exempt under any statutory provisions or exempt in common law, then they're not obligated to do anything because they weren't before. But anybody else is still obligated to disclose all those things, whether it's lead, radon, subsidence, meth lab, whatever's within any of those statutes. So the thing you can't do is lie or cover it up or not disclose everything you know. Material relevant facts are still material relevant facts. There was a case of a student of mine maybe 12 years ago. His family purchased from the city of North Aurora the old Messenger Library, and I think is it still the Moves Dance Studio downtown North Aurora on 56, where it's right by the river. Anyway, when the family bought that place, they had looked into it, and it was being sold by the village as is, and one of the village employees, thinking he was helping his employer, said to these people when they were looking into it that they had never had any problems with, like, the sewer, for example, was one of the things that we asked about. No, we've never had any problems. Literally, as soon as they closed on this thing, they went in and found that the sewer had been backing up for years and everybody knew it. So he came to me and said, what do you do? What do I do? I said, well, I'll tell you, first that's the kind of thing you call an attorney, but if it was my investment, this is what I would do. I'd go to the city and say, you committed fraud. You may not have intended to, but your employee who knew or should have known lied, and as is doesn't cover that. And so he called the attorney advised him that exactly. They wrote a letter that day, and by the end of the next day, the village had cut them a check for the credit to repair the sewer. It happened just that fast. Clearly the village had no idea. It was just an employee who meant well, who didn't realize what as is meant and what he could or couldn't say or do, overspoke and misled them. And I think they were probably fortunate in that their bid to buy it was enough higher than the next bidder that the village was still willing to say, okay, we can give them $5 grand or $2 grand or whatever the number was, but we still would have come out money ahead to have sold the place to them by bid anyway. But anyway, that's what happens. As is not an excuse to avoid liability. It's just exactly as Steve described. And some sellers will, when they say as is, what they're saying to you is, you can have an inspection done, but if it turns up problems, you have two choices: buy it or don't. Do not ask us for a credit, because we're saying to you, we're not giving a credit. Come to a dollar amount based upon the current condition, and then if the inspection's worse than you expected, walk. But don't ask us for a credit, because there is nothing in between. It's all one way or all the other. And particularly with lenders and foreclosures, that's what you're looking at in some cases. Number 7, must the civils disclose the radon issue? Certainly, right. We have Radon Act in Illinois, so that has to be disclosed since it's above the 4 picocurie per liter level. Is Maureen liable for this disclosure?
Yes, because she's
Right. If the agent, is responsible at least for getting them to look at it, and if the agent is aware or should be aware of those levels because she was involved in the test, or because they've mentioned it to her, or anybody has said anything about it, or if she knows that other houses in the area have it, then she would be liable. And she's obligated to give the disclosure either way, whether she knows or doesn't know. So she's liable for the disclosure form, most certainly. What steps must be taken to satisfy the radon disclosure laws? So what do we have to do in Illinois? We got the form, right? And then put that in front of the seller and ask them to disclose any knowledge they have or results of any test that they have. And that's pretty much it. Seller has no obligation to test. There are no federal radon laws except for the EPA's levels, which passes through to the Illinois EPA, makes them Illinois levels as well. So then it's just a matter of getting the proper disclosure and making sure that whatever material you know, the information is provided to the buyers. All right, number 8. What are the total costs involved in the repair? Whose report should receive more weight, the contractors or the home inspectors, etc.? So we'll just take this one at a time. What were the total costs that the contractor had come up with? You had $3,500 for the roof, $2,500 for carpet, so that's $6 grand. $2,750 for paint, so that's $8,750. $1,500 for interior paint, that's $10,250. And then we had $3,000 for appliances, that's $13,250. And a leaky pipe in the first floor bathroom, paint, patch and paint, another $1,500, so that should be $14,750. That's the contractor's opinion of everything that needs to be done. I don't know that everything on that list is necessarily disclosure worthy or is necessarily an obligation. Something can be functional but not be worth much of anything, like a refrigerator that's old, for example. Maybe it's energy inefficient, maybe the light bulb's burned out, but it still keeps stuff cold. I don't think that has to be disclosed, and I don't think that has to be replaced. You do it because it makes sense to do it, not because you're legally obligated to do it. Even there, you might keep that fridge and stick it out in the garage and sell it as a second along with the house as a benefit, and you know, buy a new one as an inducement or to entice them. So in some of these cases where the inspector didn't pick things up and the contractor did, whose report are you going to rely on more? Where are you going to hang your hat more?
Home inspectors.
And okay, so why would you go with the home inspector?
Because he's the professional in this.
He has nothing to gain.
Okay, so he has nothing to gain, which is different, because let's look at it from the standpoint of who knows more about each specific trade. Would you think that would be a contractor that performs that work or a home inspector who inspects that work? I think it's probably the contractor. Contractor probably knows the details, like the roof or something else, better. But it is an issue of, well, hang on, you know, is the contractor trying to sell you the job where the home inspector is really trying to look at the condition as more of a neutral party? I don't think there's a right answer here. I think this is a case of professional judgment that you'll have to exercise, in part if a client says, well, we now have a contractor's estimate and we have a home inspection, and they don't say the same thing. What do you think we should do? For one thing, I think you have to be careful not to make them a specific suggestion, because then you become an expert in which is more important. But pointing out those differences we just talked about. Steve?
I was licensed home inspector, and what we were told to do was say that there's something going on here you need to have a professional look at. So maybe get a second opinion from the other contractor.
Yeah, to be able to say that. And that's common with certain kinds of things where you have to do that. I think this might be asbestos, so I'm going to have it tested. I noticed the other houses seem to have radon things. Did you order a radon test? You might want to, you know, get that done. I'm not sure about the age of the roof. You might want to call a contractor and have them look at it or whatever. I have, you know, a roof on my house now that's, I don't know, maybe 20 years old. I keep waiting for it to leak. It looks like it should leak. It doesn't, and it's perfectly good. And I'm assuming the guy who's a friend of mine that I bought the house from, he bought it in '86, replaced the roof at one point. And so I asked him last year, when did you replace the roof? And he looked at me and he goes, replace the roof? I don't know if I replaced the roof. Well, he lived in the house for 16 years. And I've been in there for 12 and a half. So if he didn't replace the roof and I haven't replaced the roof, that's getting close to 30 years. And I'm not sure why it would have been replaced when it was only 10 years old, which is what it would have been just a little before he bought it. So either he doesn't remember, or that roof is, you know, almost as old as the house. So I mean, you know, it's kind of hard when you look at something to know, you know, what's going on with it or what is, without really doing a full inspection and taking a serious look at it. So again, use your professional judgment there. I think you have to kind of try and figure that out. The better you know the inspector, the better you know the contractors, the more likely you're going to be able to make a judgment, I think, or make a recommendation. And ultimately, please let your clients make that decision themselves. Just give them a help with what to watch out for, and don't take on the liability of being the expert yourself. Let's see, what else we got to this question here. Would it make a difference if the contractor had 25 years of experience and the home inspector only 2 years? I think it's the same thing we just talked about, right? I mean, a contractor in theory should really know that work really, really well. The big issue is, are they overselling a little bit? Because that's what you got to do if you're a contractor. I get a couple of remodeler type magazines emailed to me every month, every week, I think it's more like every week for one and every month for another. And one of the things that I've read quite a bit about over the last couple of years are remodeling contractors trying to convince each other to stop giving free estimates, which is the norm in the construction industry. You want your deck washed? Sure, we'll come out and give you a free estimate. The problem is that some contractors are finding, particularly in more complex jobs, that they come out, they do a floor plan, they do sketches, they do layouts, they do some real basic, simple design work. They look up things like permit costs and codes and all kinds of things, present this thing, and then they give that information to the homeowner, who then takes that same information and goes and buys everything piecemeal at Home Depot and does it themselves. Or goes to their brother-in-law, who's an out-of-work carpenter, and has them do it for half the price. So many contractors now are saying, sure, we'll come out, but you got to pay us. You might actually get a better estimate, I think, if you pay for it, as opposed, which is what you're getting with an inspector, and then if you have a contractor come out who their time is only worth it there if they end up selling a certain number of those estimates as jobs or as contracts. Like, it's something else to be aware of. A trend in the industry that you might see more of, fewer contractors willing to do at least complicated estimates for free. All right, number 9, are there other issues that the civils and marine must address?
The dementia.
So say that again and say it louder.
The dementia. Mrs.
Yeah, well, that's right. We kind of talked about that a little bit, but you really do have to have a firm hand on whether Mrs. Civil is competent or not, right? So there is that issue. What else?
Well, I think the plumbing leak and the radon, they have to be addressed.
Yeah, either disclose it or better off just fix them beforehand. If you have a $1,200 problem that's obvious, it probably costs you, I'm just saying, throwing out a number here, $2,000 in value, right? If you know what it is. If you have a $10,000 problem that's going to the fix for which is going to last 30 years, like replacing a driveway or a brand new roof, then maybe it isn't worth putting the money in, unless you're really stopping a leak or the driveway is so badly damaged that it's a major turnoff. It's one of those that we talked about before. The other course about increasing and diminishing returns. If you overinvest, you may not get the money back. So you do have to look at that a little bit, but yes, the simple and obvious things should always be addressed, especially where they're going to serve as turnoffs to prospective buyers. What else do we have here? A couple notes I have. In today's world, you need to look at whether municipalities require an inspection. In some cities now they do. We've got this condition issue. So if you were in West Chicago, for example, or some other villages where the city comes out to do an inspection, or if this were a rental property in a city like Aurora that has to be inspected, even if it's single family, you'd have to pass that inspection anyway. So those kinds of inspections are going to need to be dealt with if it exists in a particular municipality. We don't have any facts here to that effect, but it's possible. In which case, in those cases, the repairs are going to have to be made. You don't have a choice because the city won't allow you to transfer it in those cases if they're not repaired to their satisfaction. And I don't know, do they give us any details here in today's market? One of the things we talked about before, where are you at with your mortgage? Do you have are you underwater? Can you clear it? I don't know, remember what the details are here. We may not know that. So there's that whole thing. And then if you do get into the fact that if Mrs. Civil is no longer mentally competent, besides talking to your managing broker, if you're not quite sure what that situation is, it might be one of those cases where you try to get the family to figure out, if they don't have a power of attorney or she hasn't given one to her husband or whatever, maybe they need to be talking to their attorney about how everything needs to be orchestrated with documents to make sure that you can close the transaction, both take the listing and close the sale. So that's pretty much the other things that I had about that. Any other comments or questions about this case number 2 that anybody had left over? All right, then case study number 4. This is kind of a mess. Of course, these all are, I guess. So we have a disgruntled young person who wants a different job, a different situation, and an aunt who's a real estate agent who decides to give him a chance to make something better or see if he can make it in the real estate business, and it turns out to be fodder for a case study, which is always good for us and bad for them for a real situation. So the first question here for case study number 4, should James, the former restaurant worker, have a written contract with Aunt Betty? Should he have a written contract with Sarah? Could James earn a commission? Let's take them one at a time. Is it a requirement that he, as an unlicensed assistant, have a written contract with his aunt, who's the designated agent here that we're the sponsored licensee we're looking at?
So with Sarah, right?
Right, so, yeah, he has to, the correct question has to be yes, the first one is no, but it doesn't mean you can't. So you don't have to have a written contract with an unlicensed assistant, but it's not a bad idea to have a written contract. That would give you the opportunity to define duties and, discuss parameters and have them sign off on them having read the policy and procedures manual, gone through any other training that the broker mandates, sponsored broker mandates for unlicensed assistants who are going to work in the office or be part of a team or whatever. This is unfortunately pretty messy pretty quick. So the answer is he should have one, but he doesn't have to. And then number 2, should he have a written contract with Sarah? I really think that's probably a must. And again, an unlicensed assistant doesn't really have to be employed through a contract arrangement, but it makes a lot of sense. That's where you really get, that's where you have the binding relationship. Again, Aunt Betty, in theory, is responsible for paying him, but the broker is also responsible for those things. So if you're going to have an office where there are unlicensed assistants, I think you want a policy that says everybody who works here has an employment contract with us, licensees and non-licensees. It only makes sense to do that. It's not complicated. Once you've got 20 contracts in the office, what's 21 or 22? Just have them. It wouldn't be a big deal, but it would give you a chance to make clear, here are the things you can't do. You can't talk to members of the public about how many bedrooms and bathrooms, and all you can do is read from pre-printed statements. And then it forces you in the brokerage office to have training, which is what the Act is about in part, to keep people who don't know enough, who didn't go through all this coursework that you've gone through, to make sure they don't say innocent consumer things when they're representing the brokerage firm and make it sound like it's official information that can only come from a licensee once a brokerage firm's involved. Right? If James is working in the restaurant and he's not related to Aunt Betty in terms of business stuff at all, he's free all day long to tell everybody, yeah, my aunt's a realtor, what do you want to know? He can do that, right? I mean, while he's serving up eggs or waiting tables and cleaning dishes, he can tell everybody in the world he's a real estate expert, whatever. But as soon as he goes to work for the firm, he has to be careful what he says. And if you don't set that up ahead of time, then how can you ever demonstrate as a broker that you had good policies in place and that he's a rogue who should be punished and not you as a firm? And then the last question hopefully is fairly obvious here at number 1. Can he earn a commission?
No.
Yeah, clearly not, right? So unlicensed assistants cannot be paid in relationship to anything having to do, no bonus, no incentive, nothing related to transactional compensation. He's just paid by the hour or salaried or whatever other kind of typical W-2 employment arrangement without bonuses that you would do for an employee.
Shouldn't the contract actually be written in that office to make sure that they're aware that they are contracted by hour and not by commission?
Yeah, exactly. That would be part of what you'd want. Everything, go back to the old text, everything in Chapter 5, here's what a licensed assistant can do, here's what an unlicensed assistant can and can't do. That can and can't do for the unlicensed assistant should be right in the contract. And then when you sign it as the broker and he signs it, and then separately, like I said, when he signs off on having gone through other training or policy and procedures manual, if you ever do get into a regulatory issue or a consumer complaint, even at an arbitration hearing within the realtor organization, you could pick it up and say, look, we went through the training process, he just ignored it. That is an important defense for companies, even in safety issues, industrial accidents. Employees who go off the scale or off the chart in terms of doing something that they should have known not to do. Employers defend themselves by saying, we have these policies, we have this training, they've been to it, we can't control what somebody does minute to minute, and courts will tend to go easy, or regulatory agencies will go much easier on the companies that way. Whereas if you don't have any of that in place, how do you prove that you put forth good efforts or had good faith intent in the first place? Question number 2, Aunt Benny wanted to do her nephew a favor. Should this have influenced her decisions? What was it that the former Mayor Daley, the late former Mayor Daley, once said captured on television and radio when he was hiring his sons, and people were asking him how he could hire his sons in a difficult economy when other people couldn't find work, and his response was, if you can't help family, who can you help? So maybe that's Aunt Betty's school of thought here, but what do you think? Is it a good idea to just help somebody, in this kind of way?
Yes.
It's thoughtful, but it's also a little dangerous. If you don't have the disciplines in place, you have to be careful. People oftentimes say, don't do business with friends and family, and I hate that statement because I do business with friends and family all the time. It's almost the only people I do business with a lot of years. And the lesson is you have to paper it in the same way you always do. So the challenge here isn't whether she should or shouldn't have helped him. The challenge is if she's going to help him, she's got to treat him like any other unlicensed assistant off the street who she doesn't know. You got to still have everything in place to make it a business working relationship. Help who you want, but do it in a formalized way so people understand that. So working with friends and family is challenging because we drop our guard, because it's more emotional rather than more professional. So you're a businessman or a businesswoman when you get into this field, act like it, and then help people as part of that structure. My answer key says she absolutely should not have, helped him because he was family. I think that's hard to get around. I think you just remember not to treat them like family when you paper the agreement. Question number 3, was James authorized to make a set of keys?
Yes.
Sure, that would be a ministerial act, right? I mean, so key making is ministerial act. One thing about that kind of activity, there's a lot of stuff that unlicensed assistants can do. Was James authorized to open the house to an appraiser? Yeah, right? Not a member of the public, he's a professional, don't have to worry about that because he's not an innocent. He or she as a professional also can protect themselves. Can James talk to a member of the public over the phone? So I got a yes and I got a no.
He can quote from printed material.
Right, and he can chat casually about the weather and that sort of thing, right? So you can talk like any person, but as soon as it comes down to the details of the property, you can only quote from printed materials, or you're better off in many cases to just say, let me put you into the agent's voicemail, let me take a message and have them get back to you. One of the challenges in today's instant gratification world with cell phones and numbers on the sign is people call the listing agent. Remember, good practices have your name and your individual cell number on your signs. It costs you some money, but you don't want to advertise your office as much as they do. Right? It's they give you the signs because it's their office name and their office phone number. They don't care which agent gets the next listing. They don't care if it's you or the person in the next cube over. You do, so have your personal name, your personal cell number, people can reach you more easily. But the calls that go to the office, if you're not there at the moment, if they hand it off to your assistant, that you got that. Remember, the receptionist who answers the phone, that person is also an unlicensed assistant basically to the entire office. And so when the caller, the potential buyer, has questions and they want them answered right now, if the response is the listing agent's not available, you can get a disgruntled individual who ends up calling some other brokerage firm altogether. So it is a balancing act for offices to figure out how we provide good service, but also recognizing that it takes a licensee to answer a lot of the questions that the consumers want to ask when all they've seen is the outside of the house and maybe a flyer, and if you've got one of those phone numbers they can dial into or something, maybe they've gotten a little bit of information. So you have to figure out kind of how to balance that. Most offices tell their receptionists, transfer it to the agent on floor duty. Don't answer any questions. But again, you take those floor calls, sometimes the person's frustrated because they asked for the listing agent who wasn't in, then they got transferred to you, they don't understand why you're taking the call. Sometimes you have to educate people. People without a real estate license, Mr. and Mrs. Buyer, can't answer those questions you have. So you have to get to a licensee or you just have to wait. And then if you're on floor where you're taking the incoming leads, that's good for you because now you can ask them, are you working with an agent? If not, do you want, I can help you not just answer your questions here, but what are you looking for? I can help you find other properties, etc. Try and land yourself a buyer prospect. So again, can you talk about a listing? That really kind of goes to the front. So can he show a house to Carrie, who's a broker?
Unlock the door, yes, show no.
Yeah, so I mean, you can actually escort a broker around. You can not do anything with public as far as letting them into property. I run into a problem occasionally with the office building that I manage in that I don't have another agent. If I can't, if I get a call from a dentist, for example, who wants to see the property on a Sunday afternoon, which is not that uncommon, this thing happens to me a few times a year, I have to go and show it to them because I don't have anybody else to send, except that my wife can show the property because she's an owner. So that's how we get around that. But when my wife was in grad school in Carbondale for a year and a half, I had to go to every one of those. I couldn't send one of my daughters who sometimes would help me with locksmiths and roofing contractors and other sorts of things. I couldn't send them to open the property for somebody. Now, if there's a broker who has a client, I can go there, open it up, and I don't have to care, right? Because they've got somebody. Or every once in a while, a broker will send somebody to a listing I have, and I have to show it to them, knowing that they're represented by a broker. I think I mentioned to some of you before that I sold an apartment building a couple of years ago in Naperville as a listing agent, and we had, I think, 13 buyers come through in a one-day open house. To have a multi-unit property where it was 8 units, and the buyers all wanted to see the inside of all the units. To get 8 tenants inconvenienced over a period of time was just impossible. So we gave everybody a couple of weeks' notice with the owner's permission, and we set it up so that all the units could be seen the same day. One tenant refused. I told her, she probably was in violation of her lease, but I didn't have any authority to, threaten her in any other way than that. And so we got in to see 7 of the 8 units, and from that walkthrough, we got, I think, 5 or 6 offers that came from that. And it was much less inconvenient for the tenants. They just had to be there all day, one day, or not be there, be gone. And in that case, I was there, but I had a team of 3 unlicensed assistants with me. So when somebody came to the property without a broker, I walked through with them. When somebody came through with a broker, one of my unlicensed assistants walked them through. So first thing we did at 8 o'clock in the morning was go around. I introduced myself and my unlicensed team to all the tenants. Now they were comfortable with who was going to come through. So when the people started showing up at 9, they could recognize who was knocking on the door. And the only people who came through without brokers were people who were either coming to me or they were represented, but their broker couldn't make it that day. So that was how we handled that one. And it worked out really well. As it turned out, oddly enough, the very first people who saw it were the ones who bought it, and they were represented, but I had to walk them through because their broker couldn't make it on that day. All right, so anyway, just know how to handle that kind of situation and how to walk through that. Broker open houses are fairly common. Most houses that are listed in the MLS are open for an agent tour or broker open within the first week or 2 that they're on the market. And that'll usually be a weekday, Tuesday, Wednesday, Thursday, 9 to noon, 9 to 3, somewhere in there. Whatever you agree to with the client, you just put it in the MLS. You'll only get 4, 5, 8, 10 people who go through it outside of your own office. And sometimes it's helpful to have somebody sitting there, at least over the lunchtime. Sometimes you entice people. First 10 brokers who come get a $5 gift certificate. Everybody who comes between 10 and 2 gets, Starbucks coffee and a Panera bagel or whatever you arrange. So if you're going to do that, it's nice to have somebody there. If you can't, well then that's where your unlicensed assistant could be there to help you to do that. Because they're all brokers, you don't have to worry about that. So again, big difference, open for brokers and open for consumers. It's all, that unlicensed assistant thing is all about keep people without a license away from the consumer so we don't mislead them. or whatever. All right, Sarah was quite upset by the way Betty handled James's hiring. How could she have prevented such lax hiring practices? We may have addressed this a little bit, but what should the sponsoring or managing broker have in place?
Make sure we clear to Betty.
Yeah, every agent, so that every agent in the office knows, if you want to hire an unlicensed assistant, you bring them to me, I interview them. Or you have to fill out these forms and I approve it. Or here's the contract that, here's the base contract that's going to be entered into. If you want to do something different than that, mark it up and then I'll approve it. That kind of thing. Better hiring, policies and procedures in place, absolutely. So I think, again, how could she have prevented such lax hiring practices? That's cared for. Should James have signed, initialed a statement that he read and understood the policy and procedures manual? I think I gave that one away already. I think you got to have that in every office today. Keep in mind, this was only a law that's only a few years old. When I got into the business, most brokerage firms didn't have policy and procedures manuals, and there was no law requiring it. That law is now, 5 years old, I guess, 4 or 5. So that's fairly straightforward, and I still don't have one because it's just me. It's one of the reasons why I won't hire any agents, even if I could. Besides working here, which is probably the number one reason, I don't want to have to screw around with training and all that kind of thing and have people sign off on manuals and update them. If you want to see what one looks like, as soon as you get into the business, if you want to see what the generic or standard one looks like, after you see your offices, what their office one looks like, the Illinois Association of Realtors has a standard template online, and I'll bet you'll find that your office policy procedures manual has all of that in it, plus everything else that they've figured out they need to do differently over the years. So I'm sure they get thicker as time goes on. Question number 5, what is Betty's liability for James' actions? As the sponsoring broker, Betty's the agent. So what's Betty as the agent, what's her responsibility as the sponsored licensee?
She's accountable to Sarah.
She's responsible to her broker.
Since James is very accountable.
I think she's responsible to the state as well. I think both Betty and Sarah share liability. Everybody who works in the brokerage ultimately is responsible to the sponsoring or managing broker, and maybe the broker can get out, I was ignorant of this, I didn't know, didn't even know the guy had started here, whatever, maybe. But it's not something you want to hang your hat on. That's the kind of thing we would spend some time on in the managing broker class to really try and tighten that down. Unfortunately, there's not a lot of case information in that regard. Some brokers in Illinois tend to get away with some of that stuff, but in general, the idea is an employer is always responsible for the actions of the employee, so long as the employee, acting as their agent, is acting within the general scope of why they were hired. And he is in this case, right? I mean, this isn't the case if he was out at a disco on Friday night and punched somebody in the face because somebody said, I don't like real estate. And then you're saying, well, he wasn't at work. Anything that he does for that brokerage firm makes the broker liable or potentially liable. Same thing would be true of your receptionist or your janitor or anybody else that worked for you. All right, number 6, what is the name of the state licensing agency? Everybody knows that. Is anybody going to shout it out loud so I know you know that? Yeah, IDFPR, right. And do they have a case against James and Betty, Sarah? Who do they have a case against here? Let's take it one at a time. Do they have any kind of a case against James?
Yes.
Yeah, I think, the risk for James is that if he's doing what he's described here, he might be engaging in the unlicensed practice of real estate, which is up to a $25,000 fine per offense, for a civil penalty, and then potential criminal penalties if it's repeated. So that's his potential risk, practicing real estate without a license. So Aunt Betty, her main problem is that she didn't do any training, right? She didn't provide him with any training or any understanding of what he's supposed to do. And Sarah, she's just kind of on the hook for everything. So if he's guilty of practicing without a license, and in effect, if the brokerage firm is employing him to practice, then that's really how the broker could also be sanctioned on the same basis. Probably whatever, if anything, Betty and James get, Sarah's gonna get, the brokerage firm's gonna get the thing for the same thing. It's not at all uncommon. If you go on idfpr.com and look up license disciplines, on the real estate webpage, there's, on that front-facing page, there's 2 links to disciplinary actions, before 2008 and 2008 and after. And they're all still there. However many years, a decade's worth of disciplinary actions are there, it's not at all uncommon when it comes to something like the unlicensed practice of real estate that there's not one licensee fined there, but there's 2. There's an agent who didn't do their CE and their broker, an unlicensed assistant and the sponsoring broker. So there are certain kinds of actions like that that help make it a little clearer when the sponsoring or managing broker has their feet held to the fire. And I think this is potentially one of those cases.
So in a situation like that, where Betty's breaking the law, and they both get fined, Betty and Sarah, could Sarah sue Betty for damages? Since
Yeah.
she didn't even know?
Possibly, but what would happen there, she would first, Betty would get terminated, presuming that there's a cause of action. I mean, a good employment contract would then need to tell the sponsored licensee, Betty, that if you hire an unlicensed assistant, here's the procedures and here's all of that. If she's using some standard contract form that doesn't even address that, then she may not have any grounds for litigation, but she could still, these are at-will employment contracts, even for independent contractors, so Sarah could terminate it for cause or no cause, whatever. I don't think in a case like this she'd have any problem with Betty suing, counter-suing for, unlawful termination or something like that. The problem is I don't think you recover from that. Anytime your firm is disciplined, anytime your license is disciplined, it becomes a matter of public record. It never goes away. Go online and do a license search, and whatever name, search mine if you like. Search my last name, you'll find a range of my different licenses, and you'll find, I think, 2 other family members of mine who are former licensees. And you can just click on any one of those and just see, there's a data field, discipline, yes or no. If it's no, it's just a black N. If it's a Y for yes, it's in red. And it doesn't matter if that was 20 years ago or if it was last week. Anytime your license is disciplined, it becomes a permanent matter of the public record, and any consumer who wants to look you up, you're now one of 3 brokers going and offering to list somebody's house. If that consumer is savvy enough to say, I'm going to go to IDFPR's website and see if these agents have ever been disciplined, guess who the first one is that's going to get crossed off the list? I had a former teaching colleague that ended up losing her part-time real estate teaching position somewhere because the school where she was teaching found out that her broker's license was suspended because she and her husband were in arrears on their Illinois state income taxes by several years. So once they suspended her broker's license, then the school caught wind of that and said, okay, you can finish this semester, but you're not, they didn't suspend her instructor's license, they didn't touch that, but the school said it, and I think that was the end of it. I don't think she ever taught again after that.
Realtor I'm using right now got fined almost 30 years ago, and I'm from a small town. They made front page headlines when it happened. So.
Yeah, that doesn't surprise me. I mean, one of the things I always tell people, and for those of you who sat into this other class, you may remember, in chapter 14, it talks about the fine for bouncing a check to the state. And if you write a bad check for license renewal or whatever, that's grounds for discipline, and is a fine, and it shows up as a disciplinary action. So I always tell my students, don't do that. But yet I have had multiple past students who are listed in the disciplinary actions for when it came to renewal time, writing that check for $200 and having it be no good. Lie to your spouse, lie to your mother, steal the money from somebody, but don't bounce a check to the state licensing authority if you're making your living in real estate, because now everybody will know you write bad checks, or you wrote a bad check to the state, or they won't even know that it was just something as simple as a bookkeeping error. They'll just see that your license was disciplined, and for all they know, you stole money from a client or whatever, So, again, it is the kind of thing that happens. I've worked with plenty of brokers who've had their who've had their licenses sanctioned, they've been fined or disciplined or whatever with no problems. I think the only time it ever affected me was when I was looking at the ballots for who wanted to be on the local board of realtors for the Realtor Association, the local association that I belonged to. So I did my due diligence. It was a rare time in my life when I had time to actually look at who all these people were, see what their background was, and I decided to check their backgrounds with the state. And one of the candidates I crossed off my list as soon as I realized she had been disciplined for depositing a commission check straight into her checking account. Now, I don't know what the particulars are. Maybe it was the sale of her own house. You can imagine how this would happen. It's the sale of your own house, and the broker says you can keep the money, and without thinking about it, she just put the money straight into her account. You can't do that. It still has to go to the broker, and the broker will replace it with another check. Same thing's true with the 100% commission kind of arrangement. It may all be your money, but it's got to go to your broker, who then pays you directly. There's no exceptions to that. So in that case, I chose not to vote for somebody who had very recently made what I considered to be a classic, we teach you that in pre-license school kind of error. Otherwise, I've never hesitated to do business with somebody who was one-time disciplined. Usually it's for something like continuing ed or bouncing a check or something that's completely unrelated to practice. If it's related to practice, people don't usually get fined. They usually get suspended and don't come back, that kind of thing.
Do they check you every year?
Every
Do they have a percentage
2 years.
of people they check?
Well, they have, yeah, there are investigators that work for IDFPR. I don't know what the number is anymore, but it's tied approximately to the number of licensees. So as the number of licensees go up, in theory, they are required by statute to hire more. IDFPR is reasonably well funded. They don't have a funding problem. They have a state legislature problem. You hear about these sweep funds that the governor is reinstituted, that the assembly and the governor have been doing for years. So an agency like IDFPR that should probably receive about $3 million in fees, et cetera, from licensees and all sorts, is probably operating on $1 million or $1.25 million because the rest of these other state agencies are stealing their money, basically. So they have some challenges being fully staffed because of that. But otherwise, they have an adequate number of people, and they will send out surveys and ask questions. From that and from complaints and just from random selection, they will choose which firms get audited. I know people
They
who
choose a whole firm, not just an individual?
yeah, right. They'll choose whole firms, but from complaints, then you have to go in and answer. If a consumer complains, the state will contact you and let you know. And then they will tell you if they need response from you or not. If they look at it and go, oh, no, never mind. Once they interview the consumer and realize this is not a license law violation, somebody calls up and goes, they charged me too much commission. I paid 7%. I realize now I could have gotten it done for 5.5. I'm really angry. The state's not, that's not going to go anywhere. But if you end up with any kind of potential disciplinary action, IDFPR will appoint somebody to then call you and interview you, or you'll set up a time when you come in to answer questions. You're free to bring counsel at that point, and from there they will decide whether there will be a disciplinary hearing or not. And those meetings many times happen in Chicago rather than Springfield. They have attorneys. The staff is mostly in Springfield, but they have attorneys in Chicago. And so a lot of that interview is done up here. I think in part because the bulk of the agents in the state are up in this area.
Now, this particular case that we were just studying.
Yes.
All right, let's say this kid was licensed.
Okay.
And they still got the same complaint. Now, to me, it sounded like it was puffing. So would there be a case there, do you think? For that?
Well, consumers can complain about anything. There's a blank complaint form on IDFPR's website. I have to revisit kind of. So talk me through what's happened
Well,
here.
this kid, this
Right.
is the same one.
Right.
Where Aunt Betty hired her nephew.
Right. So if he's
And
hired, right?
What he was saying to the people on the phone,
Right.
even though he hadn't seen the listing.
Right.
But let's say he was just kind of like that anyway, and just
Yeah.
telling people, even though he was licensed, that, oh yeah, it's a cream puff, that's what he was saying.
Yeah,
I
I
thought
think
that was like puffing.
cream puff is puffing. The problem is that he's talking to them at all here. I don't know, I don't remember anything of specific license law violation other than that. Knowing what you can or can't say, what you can or can't do. That's really what this question is getting at. And some agents say and do stupid things all the time, but they're not grounds or bases for
Yeah, but now these people
disciplinary action.
actually went to the department, so
Mhm.
would that even open up a case, or
Well, that's where they would, the department will accept that and they will vet that. That's part of their job, is to vet that. So they will first, usually my experience with DPR is that they will interview the consumer over the phone. And, once they'll appoint somebody in their office, that person's job is to call up and talk through what are the details and figure out whether they think there's a case there or not. And they might even advise that individual whether proceeding with DPR or hiring an attorney or whatever, filing a lawsuit to protect your rights. They might even advise them how they should go forward if they think it's a compensable kind of offense. But then from there, once they've got that information, then they'll notify the licensee that there's a complaint against you, and here's the information, and either interview them over the phone or more likely give them the opportunity to come in and talk, and they'll ask the consumer to be available by phone usually. The consumers, they try not to inconvenience the victim, if you will, right? So then from there, they decide whether there's merits from the case. And sometimes they'll undertake a disciplinary action or try and enter into a consent agreement with the licensee without actually having a formal hearing with an administrative law judge. And it depends upon the situation, upon the circumstance, upon what it is. I've not been involved in any disciplines like that directly. I talk to people and get feedback, or students have gone through certain things, difficulty getting licensed or whatever, will share with me, and then I piece things together from that. That and just understanding law in general. So yeah, if the only offense here is that he was violating the License Act because he didn't have a license, then there's no case. And again, they could file a complaint, my agent was stupid, and it's not going to go anywhere. In fact, the agent may never even know. I don't know if they know the complaint was filed or not. I think they get advised as a complaint, but they may never actually get interviewed. If IDFPR decides it's not even worth pursuing, that'll be fine. And like every regulatory agency, as far as I know, they have more complaints than they can handle, and the ones they pursue are the ones they know they're going to win. The ones they know there's a strong case, or the ones they absolutely have to for whatever reason. Sometimes it takes months, literally months, to sort out the simplest of things because they have limited resources. Anything else about that particular case study? It's a good question. All right, so I think then the next thing we have is to go through our contract form together, right? So we'll talk about this, and that might take us most of the rest of the night. We'll see what we have time for. It kind of depends upon how much discussion we get into, how much I talk, that sort of thing. I'm probably just going to sit and do this. So you should have a copy of the multi-board contract 6.0 in front of you. If you don't, again, there's still a copy or two left up here. Grab one. Obviously, feel free to write on it or take notes or whatever. So this is exactly how you're going to see this form, except that this form will come to you in an electronic PDF format, and you can fill it all in electronically. You can just type everything in. So the practice has historically been you have to have decent handwriting. You've got to neatly print things in. Today, you can go to a contract writing appointment with your client, and you can fill in a contract either on your laptop or tablet, by typing into the PDF, or now the MRED MLS, MRED stands for Midwest Real Estate Data, but the local MLS here now has a contract writing feature inside of it as well. I don't know if it uses Adobe's PDF format or not. I've only gotten an email about it. I've not tried to use it. I haven't had a reason to. So be aware of the fact that it's fairly common today to type this whole thing up. Now, the standard procedure with contract forms has also been, once you take this blank offer sheet, basically, fill it in and have it start becoming a contract, the very last thing that the buyers would do is to sign the last page. But with software like DocuSign, how many of you are familiar with DocuSign or have used it anywhere? Have you seen it? Right, with DocuSign, it's a document that allows you to sign your name into your PC or your Mac or whatever, and it saves it as a digital file, or you actually just type it in and you get to select from several different fonts what you want your digital signature to look like, and that gets saved under your account name through the MLS or whatever, if you own a copy of a license of it or whatever. And then you, your clients, anybody that has to sign any documents doesn't actually have to physically sign anything anymore. So your clients then might actually sign, electronically or digitally, and then DocuSign verifies it, and that's acceptable today. Maybe once the whole thing is signed up, one of the attorneys might say, let's get real signatures to confirm everything is right, but it's not at all uncommon that this entire thing will all be done digitally. So just be prepared for that if you're not accustomed to that. That's going to be the norm for you in the industry. And it also means you can have terrible handwriting and it won't matter. But it is important that you can spell and type and have your way around a keyboard a little more importantly. Okay, so starting off at the very beginning of this contract form, clearly it comes from the local realtor associations. I don't remember how many there are now. There's roughly a dozen. This is used out to and through DeKalb. All the way up to the Rockford Association uses a different contract, but the association that's to the east, which would be McHenry, I think, which includes Belvedere and Boone County, uses this contract form, and it's used down, I think, maybe as far south as Kankakee, but certainly in Will and Grundy. So there are about a dozen different realtor associations around the area, which have probably today 50,000 members or thereabout, most of the brokers in the state that use this form. So the odds are this is exactly what you're going to write deals on if you're doing any kind of residential real estate activity around here. You can also, and you should, take advantage of getting training on this through your brokerage office once you're sponsored or through the MLS. It's free. You'll pay a fee maybe to become a one-time upfront startup fee of $300 or $500 or whatever it is to get started. And one of the things you should take advantage of that is to get trained on the contract form. Again, because you've got to explain this, not the legal significance, but you've got to explain the business deal and how the form works to either client or both of them, depending upon who you're working with. So get as familiar with it as you can. This is just our first chance to sort of take a rudimentary run through it. All right, so the first people's names we need up here on here are the buyers. Understand that this contract is what the seller's attorney will use to prepare the transfer documents, most importantly the deed. And so however your buyers want to take title, that's exactly how their names should be on here. So you should be asking them, how do you want to take title? Not as in joint tenancy or tenancy in common or tenancy by the entirety, but as in, is your name Betty? Is it Elizabeth? Is it Betsy? What's your, appropriate legal name that you want to have on title? Not at all uncommon that, people are using a couple of different names, or somebody might even be using an assumed name, not their legal name. So make sure you know what that is before you type it in there. Representing the buyer, which are the first people who are going to go through this, the buyers and their agent, you don't necessarily know the seller's names. So it is acceptable to put owner of record or owners of record. You can't leave it blank. You can call the listing agent if you don't mind tipping your hand that you're going to write an offer and say, we're going to write an offer, what are your seller's names? You can take a chance that what's in the public record is right. If it's wrong, they'll change it. When they come back, they'll counter with the right name or whatever. But you can just have owners of record, and that will suffice. Then you describe the property in paragraph number 2. Most important thing here is to have the correct address. You don't have to have a legal description to write a contract. We should know that by now. If you have one, great, but it's kind of complicated. Best to just use the address and the tax parcel number. The PIN is in the MLS. You can also look it up online. Township Assessor, County Treasurer, both of those websites are available 24/7. You just need a street address. That'll help you find the right property. You can get the parcel number from there if your clients don't have it. And it should be in the MLS as well. That's usually a required field. With approximate lot size or acreage of, that line in there is important how you handle it, line number 7. Many agents will write per survey in there, which is an abbreviation for pursuant to survey. What that says is that whatever the survey says, we're good with it. And if you're expecting this to be a certain size, you may instead want to write that size in there. If the MLS says that it's 120 by 150, you might want to put right in there 120 by 150, because if it turns out to be 110 by 140, that gives your buyers grounds to potentially get out of the contract or renegotiate the price because the lot's smaller than what they clearly expected. But if you write per survey, you're saying, just tell us what it is when we get there, and whatever it is, that's what we're buying. So know the difference there. And I warn you on that because many agents use that term per survey. You may have seen it, or you may see your colleagues use it. Know what you're doing with that. If you have a condo or co-op or townhome kind of thing, you might have a unit number. And also, there are parking spaces that might be deeded separately or might be deeded with this. Sometimes parking spaces, rooftop decks, other might have a separate parcel number and require a separate deed of conveyance. So that's what the unit number is on line 10, and then lines 12 and 13. So it's also helpful to know the contract form, to know what you need to know before you can complete it. As I will go over with you when we get into the MLS, and not next class, but the class after that, when we go through there, show you some documents. There are handy documents that you can download which tell you these are all the data fields you need to have before you can get that listing into the MLS. You take that with you to the listing presentation, and you make sure that everything that's a required field, you get that information. So you don't have to call the client back up the next day and go, I'm sorry, what was the size of that room again? Or I'm sorry, what was the finish? Or what happens with the window treatments? Or whatever. Same thing is true here. If you know this well enough, you can go through it and make sure you have all the information. If you're sitting with your client 8 o'clock Sunday night and they don't know some of these things, you would be better served if you'd already looked it up and knew it. Go ahead, Steve.
In this case, if there is no parking space included, you don't want to leave it blank, just not applicable?
Yeah, you can line through blanks that don't apply. You can cross through and put not applicable in those if you want. The general recommendation is to put NA. The reason that is that nobody else then writes something in it and it gets confused later. So NA is considered the better thing to do. It's harder to put lines through stuff if you're doing things electronically than when you're doing it manually. So putting N/A is probably a smarter thing to do. Line 14, or paragraph 3, purchase price should be self-explanatory. That's the offer price, or the contract price, or the counteroffer price, depending upon who's had this in their hands last. The earnest money. First thing that comes up in the earnest money paragraph is who's going to hold it. If the listing office doesn't hold earnest money, then that should have been disclosed in the MLS. That's a field in our local MLS. And then here, so if it's not going to be held by your brokerage, then you would check the buyer's brokerage. And if the buyer's, if your buyer's office that you're writing this as a buyer, if you don't hold earnest money and you don't want to hold earnest money, you're going to go with the seller, put it there. But look in the MLS today, because if they're not holding it and you don't hold it, then just click the third box. It'll probably be one of the attorneys or the title company. Title insurance companies are going to hold escrow money. They live and die with escrow money. So that'll be part of what they do. That service will get charged for as part of their closing fee. Go ahead.
A question going back to number 3. If
Yeah.
someone counters, do you have to redo this form?
Well, it's easier to just strike through and put the other price manually and initial it.
Okay.
As opposed to redoing it electronically. I don't remember how that works. I've only done a couple of deals with digital everything, and I think I was the listing agent the last time I did that, and an electronic document came to me and we handled it manually after that.
Okay.
I scanned it in and emailed it back, but a lot of places don't have faxes as handy or whatever is emailed, but I didn't make any digital changes.
Okay.
So you'll just have to see how that works digitally. Good question, I just can't answer it. I don't do enough currently. So know who's going to hold the earnest money. That's, again, you can't leave those blank. One of those 3 boxes has to be checked. The initial earnest money amount, remember, that's, how much do you want to try and impress the sellers? How much cash do your buyers have? If they don't have any cash or minimal, $500 might be a problem. On the other hand, if you're trying to impress the seller, maybe $10,000 is the way to go. You'll have to figure that out with your client, and it can be negotiated or should be negotiated between the parties. Sometimes you'll get a seller who will counter this and say, oh no, we need a lot more money, until you come right out and tell their agent, my client doesn't have any more cash. You've got their pre-approval letter, but they don't have any more cash, and once the contract is done, then they're gonna take money out of their Roth IRA, then they're gonna get the money from the grandparents, then they're gonna, sell their stock, whatever it is that they gotta do to come up with the cash. But they're not gonna do that, they're not gonna take money out of their retirement account and pay the penalty if they don't know that the deal's gonna go through. So, again, that sometimes goes back and forth. I find people are usually, but not always, fairly flexible on that earnest money, depending upon the buyer's capacity to put up more. And again, you can do multiple stage earnest money. Here's $500 now. Once all the contingencies are satisfied, we'll come up with $5 grand more, or whatever you want to work out. That's what these additional lines are here for, like 19 and 20. Paragraph 5, much of this information will come straight out of the MLS. So when you look at a listing in the multiple listing service, it will have things like amenities, and equipment and things that'll list the appliances. And you'll have to have figured out as a listing agent, gee, did that house, when you're listing it, did that house have a central humidifier? Does that house have central air? How many window air conditioning units were there? Whatever you've got, you have to have all that information because that goes into the MLS. Then the buyer's agent uses that as their checklist when they sit down with their client to write the offer, and then decides, oh yeah, remember they said the refrigerator doesn't stay, but do you want to ask for it anyway? Or the washer and dryer aren't staying, but do you want to ask for them anyway? You as the buyer's agent, the buyer can ask for whatever they want. They can ask for the car in the driveway as part of the sale. I mean, it doesn't mean you're going to get it. So this is where you go through that with them. Whatever the MLS said is out the window. Whatever any marketing sheet said is out the window. None of that matters once the buyers and sellers have agreed to this list in the contract. Right? This supersedes anything else beforehand. Items that aren't up there that you might want to have included, like the pool table in the basement or the extra freezer in the garage or whatever, that might not be listed there. Or any items that are there that specifically aren't included would be put down on this not included list. It's your opportunity, those 35 through 38, to clarify those items that are otherwise unclear. You don't want to have arguments over personal property at the closing table. Have them when you're negotiating the contract. Swing sets are another, that kind of thing. Everything works, basically what 39 and 40 says, except, so if there's anything that isn't working, in my house currently I have a solar heat assist system. Never worked in all the years I've had it. Didn't work for most of the years that the previous people owned the house. House got struck by lightning and it fried some of the relays in this system. We have no schematics. It'll blow cold air if I turn the thermostat up in the winter, but that doesn't help, so we don't do that. So if I don't get that repaired before I sell my house, that's got to be listed in the contract. It's got to be listed in the disclosure form, and it should be put on here. Everything works except, that solar assist heat system. I'm not going to spend 10 grand to tear it out and patch the roof, so I'll just give it to somebody who's more industrious than me if I can't get it fixed in the meantime. Important language on lines 41 and 42, this goes also to the inspection things. A system shall be deemed to be an operating condition if it performs the function for which it is intended, regardless of age. So, going back to our previous example here tonight, where we're talking about the condition of the roof, tonight or last time we were together, if a person signs this contract, then has an inspection done, and the inspector says, you should get a roof certification done. A roofer contractor comes out and goes, that roof's not going to last more than a year. But if it doesn't leak right now, you bought the house with the roof the way it is. It's not grounds to get out from underneath a deal when a particular physical property, physical item functions in the manner in which it was intended, even if it's going to wear out 5 seconds after closing. Right? That's what the contract clearly states. So understand that if you're concerned about something, you might want to make it, your buyers might want to make it contingent upon a roof certification or whatever else. A roof cert generally is done for FHA loans. It's a certification by a roofing contractor that the roof has at least 2 years life left on it. Notice at the bottom of all these pages, buyers and sellers have to initial every single page. So when you write the offer with your buyers, have them initial every page. And when you're the listing agent and you get the offer, have them initial every page. It makes sure that they've seen everything, and it confirms to the other party that everything's been seen and makes it harder for people to say, I didn't see page 5, and you're sitting there going, oh yeah, it's all boilerplate, I never thought about explaining something. So this way you kind of have to go through everything with your clients. Closing date on the top of page 2. Have a calendar with you. Try not to pick Saturdays, Sundays, or legal holidays. Also, try not to pick 4:30 on the afternoon of the last day of the month, especially if it's a Friday. Maria can tell you all loans. The world would like every loan to close between noon and 4 p.m. on Friday the 31st of every month. You just, it's convenient. Apartment leases end, so you get that kind of pressure in the market. Mortgage payments are convenient if they're at the first day of the month. So it's an easy thing to zero in on, but it's a lot easier to find closing space on the 4th, the 5th, the 8th, the 12th than it is on the 28th, 29th, 30th, 31st. So know your client's situation and know what can be worked out, and it may have to be negotiated between the parties. But try and be sensible on what date and that can be. Possession's pretty standard. It's usually at closing unless there's something else arranged. Paragraph 8 is pretty important also, functionally very important, the mortgage contingency, or referred to as the finance contingency. There are really 3 ways in which to do this. One is to be a buyer who's contingent on finance, and that's normal. That's the standard. Not everybody can pay cash for homes. Many investors can. Many people who have lines of credit or are going to use their home equity, that they have to buy a second or investment property can end up being cash buyers. But most buyers require some kind of financing. I did a deal a few years ago where it was a cash offer until we got the price up a little bit. Then they said, we don't have that much cash. This was like a $500,000 deal. And we got it up just like another 20 grand. Well, we don't have that. So literally it was contingent on them being able to borrow. I think they finally said, we want the right to borrow like a 20% of the purchase price. But what they needed was 20 grand. So that must be a nice situation to be in. But that was their circumstance. So if you're contingent on financing, then you go through the contract the way we'll go through it now. You just say it's contingent upon financing, line 52. Basically saying, if we apply for the kind of financing that's here and we can't get it, we can walk with no penalty. We get our earnest money back. So you disclose by checkbox, is it a fixed loan? Is it an adjustable? Then whichever it is it conventional, or is it an FHA or VA loan? Or some other kind of financing? And what the percentage of the purchase price is. 80% loan to value? 95% loan to value? This is the buyer telling the seller, here's the kind of financing we're going for. And then the seller can look at it and go, what do we think the likelihood of that financing is? Because if the buyer says, this is contingent upon getting 100% loan at 2% interest for 80 years, and the seller goes, okay, and signs that deal, and the buyer can't get it, what can the buyer do? Contract theory says buyer can just walk, get their earnest money back, and the seller and their agent were goofy forever agreeing to that possibility. So as the buyer's agent, you need to know what's reasonable in the market and what your buyer is qualifying for, so you can put something really close to that. If current interest rates, let's say current fixed rate, 15-year fixed rate loans are 3% right now, you want to, you don't want to put 2 3/4 if you know the seller is going to reject that. If you put 3 and the rates go to 3 1/8, the buyer wouldn't have to buy the property, but maybe the buyer will still qualify at 3 1/8 or even 3 1/4. So even if the rates are currently 3, if your client's comfortable with 3 1/4, maybe you put 3 1/4. But don't put 4 if at 3 1/2 they don't qualify anymore, or at 3 1/2 they don't want to buy the house if rates go up significantly. Most of you aren't used to this. Rates could have going up significantly in a period of a few weeks. But on my first house, purchased in Aurora in 1980, in the 60-day time frame from the time we applied to the time we closed, the rate went up 1.5%. So a little bit different world today. But anyway, just recognize that rates could go up, fairly significantly. Both buyers, agents, and sellers need to know what's right and what's reasonable for different types of loans. All right, so all that kind of thing, whatever you're gonna have, all that detail goes in there to basically tell the other party. So that's the idea of the mortgage contingency. And it has to be applied for within the time frame that's here. You know, you've got to apply for it within 10 days, I guess it is here. Make the loan application within 5 business days, and the appraisal is ordered within 10, excuse me. And then below that, the time frame within which the buyer actually expects to get a loan commitment. So you have to apply in a timely manner. God, I remember the days when that wasn't there. It just said you would apply, you'd get financing, and then they'd never go and apply. And you'd have sellers going, well, hang on, you don't get your earnest money back, you never even went and filled out the damn paperwork. And buyers going, doesn't say I have to. So clearly here now, time is of the essence, and we've put specific time frames on that. A buyer who fails to apply for the loan that they've said within 5 business days is in breach. They're in default of the contract. Better, of course, if you've got pre-approved, and so this part of the application is very easy. Just walk in with a copy of the contract, or better yet, your agent faxes it or emails it to the bank, to your loan officer, and says, here we go, time's ticking. And then, you go from there. But then you also need the end time. So you need to know, before you write this offer, how much time does your buyer's lender need? Can they close a loan in 2 weeks? They need a month? Is it something like a VA loan and a little hairy, and they got to get documentation that might take 8 weeks, 3 months? Again, how patient will the seller be? They get to react to that. So all this is negotiable, but you need to know what that is before you sit down to do that. Now, if you are going to purchase not contingent on financing, there's 2 ways to do that. Those are the other 2 ways out of the 3. One is to just do the contingency like we talked about. But a cash buyer isn't necessarily a cash buyer. A cash buyer is somebody who's actually got the cash and they literally don't need the financing, so the contingency can just be crossed out in its entirety. Doesn't apply. But somebody who's willing to take the risking in effect their earnest money, that they'll get the financing to look as strong as a cash buyer, so that in a multiple offer scenario they look like a stronger offerer, might need financing, but they don't want to make the offer contingent on financing. That's a different thing, and those 2 things need to be differentiated. I think when you go back here to the back, this is paragraph 36, which is an optional paragraph. Right. So we'll look at that when we look at on page 10, paragraph 36, transactions not contingent on financing. Either of the following alternative options is selected, the provision of the mortgage contingency shall not apply. So is it an all cash or is it a mortgage, even though you're not contingent on financing? So again, different kinds of cash buyers, those with financing and those without. All right, so we'll look at that in a little bit. Questions at all about that whole finance paragraph? Again, get comfortable with finance as much as you can in the industry. Understand what's happening, have loan officers you can talk to, people you can get a sense of, talk specifically to your buyers, your prospective buyers, your client's lender. How long for this kind of loan? Know in advance how long it's going to take to process it. Paragraph 9, all these statutory disclosures that we've been talking about have or have not been received or handed out. It's a good checklist, reminds you. Have those things with you all the time. So if you look at this and go, yikes, forgot to give you this. Here it is. You can hand it out so they can say, yes, they've got it.
Can I grab the door?
Yeah. We're gonna take a break right after this anyway. But please, you don't have to ask. You can just My favorite thing in teaching is when I'm too loud and somebody comes across the hall and closes our door instead of closing their door. It's happened to me a few times. So there's a good checklist here so that we don't forget these. This is the best checklist that this contract has had in my memory. So you go through and make sure that's all there. Many of these things are, if not all of them, are available in PDF format, and you either hand them to them or you can email them to them on the spot so that they can say, yes, we've received it. I prefer PDFs. And those disclosure forms can be typed, filled in as PDFs as well for radon and lead paint. I wouldn't, as we talked about, don't do the home disclosure, but those other ones you can probably fill those in that way, I think. All right, let's go ahead and take a break. Let's come back at 8 o'clock or just a few minutes thereafter, whatever, and we'll pick up and talk about prorations.